Hello everyone. So in today's video we are going to discuss what is a criminal liability in case of a dishonor of a check. There are many instances in which if you pay a check to somebody and if that person goes to a bank or some other places and give that check, and if that check gets bounced, in that case whether there exists a criminal liability or not. So you must be confused with what this dishonor means. Well, the bouncing and a dishonor are the same word. Dishonor of check or bouncing of a check, both are the same thing. So moving further with this answer, when a check is drawn by a drawer you can consider as any person is dishonored by a drawee. Drawee in this case can be considered as any organization or place where the check is given. For example, consider drawee as a bank. Due to lack of a cash, the drawer is considered to have committed the criminal offense. It is the general perception that the check is being bounced because of the less amount or the amount which is given in the check does not matches with the amount which is present in the account of the bank. So the section 138 to section 142 of the Negotiable Instrument Act 1881 deals with the criminal liability in case of a dishonor of a check. So from next time if anybody asks you what is a legal provision in case your check gets bounced, then the legal provision is present in the NACT, which is known as the Negotiable Instrument Act, along with some of the provision of IPC, which we are going to discuss further in the answer. So, Negotiable Instrument Act 1881 deals with the drawer's criminal liability in the event of a check being dishonored because of the substance of the offense under the section 138 of the act and the section 420 of the IPC. Deferred conviction under one provision does not provide the prosecution under the other. So when section 138 of the Negotiable Instrument Act along with the section 420 of IPC provide the legal provision in case of dishonor of a check, and you can proceed using either of the legal provision to the court or wherever places you are going to file a suit. So to discuss this concept better, we will discuss a case law, and the name of this case law is Veerbhadra Rao versus Government of Andhra Pradesh. So in this case, we are going to discuss only the judgment part of the case, and the judgment part goes like this. The full bench of Andhra Pradesh High Court held that when a person issues a check or post-dated check, he implicitly represents to the payee that the check will be met when presented to the bank in the ordinary course of the event. Even with the introduction of the section 138 of the Act of Prosecution under section 420 of IPC is maintainable in the situation if dishonest intent at the time of a check issuance is established. So what is the judgment of a case is that the bench said that when the check get dishonored, in that case the intent of a person should be dishonest or guilty intent. In that case only you can file a suit which is maintainable under section 138 of the Negotiable Instrument Act, or either the prosecution is made under section 420 of the IPC. So the next part of this question is what are the exception. Exception constitute the most important and the crucial part of any answer, and the exception of this question is the normal principle goes like this. If a check get bounced, in that case you can file a suit against you can file a suit taking the help of a section 138 of the negotiable instrument. But what is the exception in which the respondent can take as the standing thing? So if the check is issued to discharge a liability, in this case it constitutes an exception to the criminal liability. You can read the content over here. Next thing is check presented as a gift. If a check is presented as a gift, in that case it constitutes an exception of dishonor of a check. Last but not the least, absence of mens rea. If you are law student, you must be well acquainted with the fact what this mens rea actually means. So yeah, For the dishonor of a check, the mens rea is very much essential, and if there is absence of a mens rea, then in that case, the criminal intent or the criminal liabilities with the person who is presenting the check does not prevail. Thank you so much for watching this video.